Hi folks, you're with Tacitus today at your Pushback channel, and thank you for joining this radio or audio rather live stream. In this essay, I'd like to talk about a legal case from the early 1850s or late 1840s, going into the 1850s, where a slave by the name of Dredd Scott, Dredd suggesting it's been some sort of diminutive of the word Ethelred or the name Ethelred, I don't know, but Dredd Scott, and his case as a black slave, his case has sort of reached mythical folklore proportions in the role it has in the wider discussion today about slavery, the issue of reparations, black victimhood, white wickedness, and so on. So it goes into that wider melting pot of screaming and shouting that we see all over the place, which is being ruthlessly used by the globalists to exploit, create, and further racial division in the West, which of course makes it easier for the globalists to come in and take over a society that has lost all confidence in itself. It's in a permanent state of turmoil and conflict. So make no mistake, this is being seized upon by the globalists as being very useful for their agenda. Nonetheless, let's look at it on its merits. So for those who want to look it up, it's Dredd, D-R-E-D-D, Scott versus Sanford, S-A-N-F-O-R-D is the lookup there, and it's very hard to find objective information on this now because it's been heavily politicized and airbrushed by the activist class. So other than the dates that a legal document was filed on this date in this court and this place, that sort of thing. Other than that, there's a lot of backfill, if you like, activist propaganda backfill by the activist class. So it makes it a little difficult to separate fact from fiction here. But here's the essentials of the case. I've had to make some notes here. You could easily do a 2-hour documentary on this, but given the amount of twists and turns, but Dredd Scott was a slave born in legally slave-owning Virginia in 1799. He died in 1858 at the ripe age of 59 years old, nearly 60 here, and from tuberculosis. So this idea that he was a slave, outrageously treated, starved and beaten and kept in the cell and never seeing daylight is absolute and utter nonsense. 59 years old for anybody back in the day was a pretty solid innings. So he must have been, until he got tuberculosis, of course, he must have been in quite good health. And he was, up until the time he got tuberculosis, he was working. He was, as I understand it, at least, he was a porter at a hotel. So, lifting bags and moving them around. So he must have been in good enough health to do that, suggesting generally quite robust health. So now you don't have robust health back in those days at the age of 59 if you've been existing on a poor diet and so on. So or if you've been beaten within an inch of your life. So none of that is something you can hold up. So Scott was he eventually became a private citizen by private agreement, not through legal means. In 1857, not that long really before he ended up dying, but so again he was freed by private agreement with whoever the owners of his labour contract were. This is something that the articles I've found play down considerably. They want to really gin up the legal struggle side of things. And avoid covering the fact that he eventually ceased to be a slave, and by a private agreement with the owners. So the drama began here, I guess, when in the 1830s, when Scott was sold to, and I'll come back to this sold thing and sort of run the idea of slavery versus labour contract versus ownership, those sorts of things. And I'll come back to that because it raises the moral question, which the activists particularly try and fan the flames of. So Scott, now I'm assuming he's literate, given some of the work he's done. I assume he can read. And that would appear to have, given the amount of white Christians he was sort of around, that would suggest that he learnt to read by reading the Bible. I would guess it comes from that. That's not specifically stated, but it appears he's literate, or at least literate to a degree, and that it came from Christian teachings, and thus I'm assuming the Bible. I could be wrong. So he sold to an army doctor, or surgeon, as they called him at the time. And he was, if you like, the personal attendant or the butler, call it what you will, of this army doctor. Who now this doctor did a lot of travelling, so he's constantly going around to different frontier forts and military bases, things like that. And this is in the 1840s. So he sold an army doctor, and they did a lot of travelling around, but in 1836, so it must have been before the 1840s, in 1836 he moved to Illinois with this doctor. And now Illinois at the time, and subsequently for that matter, Illinois was a slave-free state. So effectively you've got the northern states do not have slavery as legal, and the southern states do. Now, there are reasons for that, and I'll come back to that in a minute, but there are reasons for that. The North was industrializing at a great pace, and so slavery and industrialization were not seen as compatible. Now, there were certain functions in, say, large plantations, such as cotton plantations or tobacco or things like that, where there's vast acreage under cultivation, where machines, at the time at least, machines just weren't usable or employable. So industrialization in agriculture intensive areas was far less, but the need for labor was far greater in proportion to the North. So the need for labor was huge, and not just seasonal labor, but people there all the time to work the farm. And slavery was worked well with that. Now, there's a number of reasons. In the South, in the swamps areas and that sort of thing, white people didn't do anywhere near as well as they did in the North, in the the industrial areas there. Black people were particularly resistant to diseases. They seemed much hardier, their constitutions, in terms of diseases that caused problems for white people, and they were able to work in those conditions, the heat and that sort of thing, far more effectively than white people could. So they were really, they were the worker of choice for that specific environment and situation, and so they're being selected there. If white people could have worked, if other people could have worked, if the local Indians could have worked in those environments, the need for bringing black people would never have occurred. So it was a confluence of events there, and in Black Africa, there was a surplus population that the black people in Africa were busily enslaving each other and selling them off to Arabs or to the white slavers and everyone else. So again, nothing to do with white people; it was the black people enslaving each other. Now, because Dredd Scott was temporarily in a non-slave state, it was argued by him in a legal case that he was therefore free and no longer a slave because he'd been in a slave-free state, that being Illinois. This is an interpretation of the law. Where was the contract originally made? Where was was Mr. Scott born in a slave-free state or slavery stayed, and so on. So there are various technical legal arguments, but this began a series of legal manoeuvres over about 11 years, I guess, where white Christians were paying for Mr. Scott's legal fees, for the filing fees in the courts, and actually and the number of court cases, as in lower courts, appeal courts, circuit courts, and then the Supreme Court. 12, I think it must have come to. So we're talking ongoing legal action over 10 or 11 years where Mr. Scott was able to have lawyers provided for, all the filing fees paid, everything paid for, and was able to launch this all the way up to the US Supreme Court, was able to launch all these legal maneuvers, all paid for by white Christians. Now, if you read the history of it, that the activists write, that they mention that there's that there's lawyers provided and paid for. The way the activists spin it is that these people had just become suddenly very guilty of their evilness and their wickedness and their badness, and decided at the last minute to do the right thing, that sort of stuff. So they try and spin it that way, but and try and still keep it as a white guilt story, rather than slavery abolitionists and Christians, along the lines of the English William Wilberforce, and that these people were opposed to slavery purely on a moral basis. It was a moral bad. Now, the technical arguments that were being put back and forth weren't necessarily about a moral good or bad, although that scored a mention. It was about the pure technical realities and the legalities of the law at the time, and laws of contract, laws of ownership, and so on. So the toing and froing was very much about that. In the lower courts, Mr. Scott won a couple of times, but in the areas where his lawyers, Mr. Scott couldn't have filed the papers and done the documents, but his lawyers, all of whom were white, by the way, they were arguing that in a slave-free state that Mr. Scott had certain rights because it was a slave-free state. Now, if you look at some of their filings and their arguments, they're actually drawing quite a long bow. If I was a lawyer going there, I would have thought the chances of making that stick under appeal were about zero. But nonetheless, and it's interesting how often in the lower courts Mr. Scott would win what looked like an activist decision, just pure anti-slavery rather than on the merits of the case, and how easily it was overturned on appeal. And you can see why the appeal was made, because the decision was made along ideological lines, in effect, to free Mr. Scott, whereas the appeal was very much along legal lines. So you've got a moral issue even coming in the 1850s. So anyway, all this to and fro, but Mr. Scott's legal fees would have been monumental. So there's no way he could have done this, or that this would have even existed for the activists to pour over today if white Christians hadn't paid for it. Now, to me, a headline of the story is, all the work that the white people did on behalf of Mr. Scott. Again, for moral ideological reasons rather than anything else. But the Christian conscience of, or the Christian beliefs of these people, and their conscience over, is slavery a moral good? I think that's very much an equal headline, but that's been just airbrushed out of the thing, and it's a case of white wickedness and black victimhood, and that's the only line they want to run with, and I think that undermines this wider story here. Now, Mr. Scott wasn't a slave in the sense he was in the cotton fields, getting the cotton and that sort of thing. That wasn't the paintings, and there's a photograph of Mr. Scott, which is in the thumbnail, where he's dressed up in as far as the sartorial splendor of the day goes, he's dressed up in a pretty sharp suit, bow tie, the whole 9 yards. And he wasn't used as a farm labourer or that sort of thing, which is what nearly all the slaves are being used for. He was used for very much an in-house, again, a butler, and given he was literate, like he worked in a general store, porter in a hotel, and so on. In 1846, Dredd Scott's given the money to buy his own freedom, but it doesn't. He offers a sum which is relatively paltry. So it's less than a year's, or approximately a year's worth of revenue that he would generate by being hired out to someone else. It's like a labour contract hire. He doesn't, Scott doesn't do himself any favours. He actually runs away shortly after being sold to the army doctor or the army surgeon. And it's suggested that the army, he didn't like the moving around and the travelling and the lifestyle, with this army surgeon, which seems odd given he was freed from pretty much any labouring in the fields and that heavy work. So you think he'd rather liked it, but he ran away. But instead of going to a slave-free state, which you think would be an obvious move given it bordered the state he was in, he instead, I think, went around like Louisiana and a super slave state and was hanging around with the slaves in a slave state instead of running away. I found that a bit difficult to comprehend, but anyway, so he was picked up and was sent back to his owner. Now that didn't that he didn't do himself any favors legally with that. So that was something that in the subsequent legal cases it had to be overcome, that he was a flight risk, these sorts of things. So anyway, he wasn't successful in buying his freedom. The amount of money simply wasn't enough. I mean, if he stumped up more cash, he probably could have done it. But all that money was all provided by white people anyway. So he's filing suits in various courts. Now he wins his freedom, as it's stated here, while he's in an Illinois court, I think it was, which is a free state. But that's overturned on appeal shortly afterwards. And from the little bit I've looked at, the grounds for the appeal were quite reasonable, and on the technicality of the law, again, the appeal should have won, and the lower court decision should have been overturned. Now he files suit again, all paid for by white Christians in a court in St. Louis, and there's extensive sort of legal acrobatics going on here over legal technicalities, the meaning of a word, the meaning of a term, the meaning of a contract, and it's really being poured over in the minutiae here, and you can see the fault lines of activism. You can see that the pro-slaver people are insisting the contract be honoured, and the anti-slavery people are insisting that the moral question enter into the whole legal sphere, and you can see the pushing and shoving in and around it. Something you still see today, by the way, activist courts, that sort of thing. Now he won again in a lower court in 1850. Again, all white lawyers, all paid for by white Christians. Mr. Dredd couldn't have done any of this on his own, and that was overturned again in a higher court. Again, the same dynamic. The lower court sort of looks at the moral issue. The appeal court looks at the strictly legal issue. 1853, Mr. Dredd does another lawsuit again. He loses. Then he goes up to the US Supreme Court. Now you can imagine the cost and the legal infrastructure required. Again, all paid for by white Christians. So this goes to, and this is the pointy end, I guess, of the activist thing here, where it's called Dredd versus Sanford, and it's in 1857. Now, the Supreme Court, James Buchanan, I think, was the president at the time, and the activists alleged that Buchanan was an evil white supremacist. He was a Nazi and a fascist, and so on. And worst president ever. And not a good president like Barack Obama and Bill Clinton. He was a bad president. Now they assert that he was wanting to create social. Buchanan, was wanting to create social division, and so this was him, and he hated black people and white supremacy, and so the activists go hardcore on Buchanan. Buchanan was at a difficult time. You wouldn't want to be president at the time Buchanan was, but he knew, and as many onlookers knew, that the Union was starting to splinter and disintegrate for a variety of reasons. Slavery was an issue, but it's been invented or reinvented today as the prime. We went to war to fight slavery because we're moral good guys. That's bullshit, utter bullshit. And it's only come recently as the activists have tried to gin it up into a frontline or headline issue. But Buchanan knew that the Union was disintegrating, and he was trying to not create a scenario where that splintering would continue or get even worse. He was trying to hold things together and hope that the drama would blow over and sort itself out, or would be finally dealt with through negotiation. Now, the issue at the time, how much power did the federal government have, and how much power did the states have? Remember, this was a union of states. So the states had their own independent government, and the federal government had a role, but in things like foreign policy and that sort of stuff, not in the day-to-day management of the affairs of the states. So there's a real argument here about what authority does the federal government have, what authority do states have, and indeed what areas of law and so on are covered by state authority versus federal authority, and how far does the legal authority extend. So this was very much a burning issue at the time, and the states were asserting their own right, quite reasonably, were asserting their own rights, and the federal government was wanting a bigger role in things. Now, there were issues that the government couldn't really, or were issues of contention that, in fact, haven't been even sorted out to this time, where if, say a criminal, someone's committed a crime, crosses from one state into another, does that matter then become federal? If it's still a state issue, which state is it? The state where the crime allegedly occurred? Is it the state where the criminal has moved, or the alleged criminal has moved to? If they've stolen property and gone to another state, does that mean it's a federal issue? And so on and so forth. Now, it's not I don't think it's a hugely complex area of law, but it was used at the time to where the federal government wanted to use that. He crossed state lines. Ooh, that meant it was a federal issue. Now, I mean, we can argue about the semantics of that, but that's something that was really big at the time. And you could see where both sides were coming to a point of pulling guns and shooting each other, which indeed happened in the American Civil War. And the southern states in particular wanted to protect state rights, not simply because of slavery, but because of the idea that those states should have rights that would be independent of federal government encroachment. So that was, and again, seen as a very, very important issue back in the day. So the Supreme Court made the decision that the issue about, this is with Dredd Scott versus Sanford, that it was a state issue, and they didn't want to interfere with states' rights. Now, this is where the activists come pouring in. They're saying, well, the federal government, like Barack Obama would have, he'd have got right in there and he'd have kicked ass, he'd have sent in the feds and those were different times. And Buchanan, even Lincoln, they thought, well, it's better to try and hold the Union together rather than to go to open conflict. So the Supreme Court made a decision that it's a states' rights issue, this whether Mr. Scott was free or not, or under what conditions, or under what contractual arrangements and that sort of thing. So that they fobbed it off. Now, the argument that the activists have today is Buchanan, because he was buddies with the head of the Supreme Court, that he had private, there's no proof of this, by the way, he had private conversations with his buddy to say, well, look, make a decision in favour of the states rather than don't make a decision. It's a federal government issue. Now, Buchanan wanted to, if Buchanan did have any influence at all, and that's no proof of that, I don't believe, or no satisfactory proof, that to make a decision in favour of the federal government would be hugely inflammatory to the states that were talking about states' rights, which were, again, primarily the southern states, and that therefore it's better to pass the decision back to the states on Mr. Scott's case, pass that decision back to the states, which would then leave the federal government free of any being tarnished with this idea of a tyranny attempting to overturn the states' rights to govern themselves. And and you can see, I think anyone in Buchanan's decision would have done that, assuming again that he influenced it. And I think the Supreme Court made a decision that the matter was a states' rights issue, which is why this overturning of Roe versus Wade has so inflamed the leftist activists. State rights means that the people decide, whereas a federal government legal edict means that no one's allowed to decide anymore. So the moral issue can become the legal issue and then enforced at the point of a gun, which is very much the left's view on how the law should be conducted. So coming back to that means Scott lost, in effect. Now, he got his freedom anyway, but the ruling said that the Supreme Court couldn't interfere, well, there's states' rights, but it couldn't interfere in this, or couldn't make a decision, because as a slave, Mr. Scott was not a citizen. Because he was not a citizen, he therefore did not have the legal rights under the Constitution that that any citizen would have. Therefore, it was that the Supreme Court couldn't buy into the argument because of the legal standing. Now, this is considered, what an outrage! What an outrage! This is a fucking outrage by Nazis. Now, let's flip on the other side, where the Supreme Court says, well, we're not going to buy into questionable electoral practices because we don't have the standing, and they go, oh, that's good. Oh, gee, the Supreme Court did what they're supposed to do. So this idea that the court's decision is only good if you like the decision, and if you don't, it's evil and bad and Nazi and fascist. We've got to just dismiss those arguments out of hand. But on the issue of Mr. Scott not being a citizen, therefore not having those rights, that's the sort of the clearest, as the activists see it, the clearest expression of, well, there you go, black people are second-class citizens, therefore the world is run by Nazis, therefore compensation, and so they run that argument, and that's what we're seeing today as a narrative and dialogue that's controlled by the activists. Now, the Dredd Scott case really had disappeared until the black activist, civil rights movement, and it was also ginned up by Soviet agitators and activists, but it didn't really kick off in a big way until the activism of the 1990s, where now Mr. Scott and his wife have got statues and plaques and obelisks and plinths everywhere you look. So Mrs. Scott certainly become useful for the activists. But that's the thing of it. Now, coming back to the idea of the slavery thing. Again, I don't like the way the slavery narrative is cast. It says only white people ever did it. Only white people were doing it. White people went out in the jungles of Africa, randomly grabbing black dudes and black people, throwing them onto ships and sailing away. Yeah, that's absolute crap. The slaves were whipped and beaten and starved, and hardly a single slave survived. And then they got to America, and then they were beaten and starved. Those lies, all lies. Can they find a single slave that would have been beaten? Sure, but as they could find many white people who were being. Remember, the sailors on ships could have dozens of lashes of the whip, for really minor infractions. So this idea that it's a treatment reserved exclusively for black slaves, again, is lies, all lies. Now the slavery's been going on for thousands of years, and the white people came very late to the game. The only thing the white people did differently with slaves, I think, as far as I can tell, is they ran very successful commercial enterprises that had some slave labor or some slave input, whereas you don't really see that elsewhere in the world, or the slaves were castrated and therefore didn't procreate. The majority of slaves in the United States were born in the United States. Insofar as the cost of transporting slaves that distance and having them in good physical condition when they arrived was so great that it was much cheaper to procreate, have slaves procreating in the United States than it was to transport them. This idea that slaves would arrive as emaciated skeletons, nobody would have bought them. Now, for the slave traders and the ship owners, their job, and if you look at the requirements of the slave markets, the requirement was that fit, able-bodied people ready for work have to be made available. So if they weren't feeding them well and exercising them and doing this sort of stuff, there's no way they could have sold them at a profit. Now, and if the mortality rate, the mortality rate of the crews, the white crews of the ships at the time was about 15%. But being out on the open ocean must have been pretty hazardous in these ships. But this includes people like being washed overboard in a storm or something. But the mortality rate for the slaves was about the same. So this suggests there's no difference between white and black mortality rates on the slave ships. Is slavery a moral wrong? Of course it is. I mean, no debate needed on that. Were the whites uniquely morally bad? No, absolutely not. In fact, in the overall moral scheme of things, the whites were well down the list in terms of not only how slaves were acquired, but how they're employed and used and so on. So this idea that whites are uniquely bad and are held up as the exemplar of wickedness and Hitler and all this sort of thing, that's absolute and utter nonsense, and we need to start pushing back. You've been with Tacitus today, your Pushback channel, and thank you for listening.